Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gabb. I'm a senior member of the IEEE and partner at the Edwards Wildman Law Firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's computer magazine each month in 2012. This podcast is part 3 of our series. In the last podcast, we discussed the enforcement of intellectual property rights. In this podcast, we will cover privacy and data security. Joining me today for this podcast is my colleague Tom Smedinghoff. Tom is a partner in the Chicago office of Edwards Wildman. Welcome, Tom.
Thanks, Brian.
Tom, there's been an explosion of offerings in the so-called cloud computing space, where resources such as applications and data storage are provided to business users over the Internet. This means that those resources are physically located away from the company that owns the data, in the cloud and managed by somebody else. The company, that is the customer, may not even know the location of the resources processing and storing its data. I suspect that this raises a host of privacy and security concerns where a business relies on cloud-based resources to process its sensitive data. Am I correct?
Yes, absolutely. Whenever a business outsources its information technology functions, or even when it merely stores its sensitive data in the cloud, it's still obligated to protect that data. As the saying goes, you can outsource the work, but you can't outsource the responsibility. The laws and regulations requiring data protection still apply. Thus, some of the biggest legal concerns for any business that uses the cloud revolve around meeting its privacy and data security obligations with respect to the data held by the third-party cloud provider. To that end, some U.S. federal regulations, such as those in the financial and healthcare sectors, specifically require businesses to ensure that their third-party service providers are capable of maintaining the privacy and security of personal information entrusted to them. And some state laws and regulations, and most notably in Massachusetts, obligate businesses in all sectors to contractually require all third-party service providers to implement and maintain appropriate security measures in accordance with the requirements of state law. Also, the European Union data protection laws essentially impose the same requirement on all businesses that use a third-party service provider to process or store personal data for the business. Another important issue relates to the EU restrictions on cross-border transfers of personal data. These restrictions raise key privacy issues if the cloud provider's servers are located outside of the European Union. This is because the EU data protection laws prohibit transfers of EU-originated personal data outside the European Union unless the receiving country provides for a, quote, adequate level of protection. Currently, the European Commission considers only a handful of countries to provide an adequate level of data protection, and the United States is not one of them. Thus, the transfer of personal data to a cloud provider in a country that does not provide an adequate level of protection is prohibited unless certain alternate legal mechanisms are in place to ensure that an adequate level of protection exists, such as approved contracts or adherence to what's known as the U.S. Safe Harbor Program. So the bottom line with respect to cloud providers is that addressing issues like these often require a combination of due diligence regarding a cloud provider's servers' locations and security practices and the negotiation of appropriate contract terms.
The laws, regulations, and other requirements on data privacy and security are literally all over the map. In the U.S., there are federal laws as well as state-specific laws. The European Union and many other countries have their own and often different laws and regulations. So it seems that both businesses and cloud computing service providers need to comply with many different rules, and it may be difficult to determine which rules apply.
That's right, and it applies both ways. We can look at this from both the perspective of the business customer and the cloud provider. If you're a business selling a product on the internet, for example, you're likely collecting data on existing and potential customers. To keep your overhead low and facilitate access to your sales and marketing data, you might decide that you want to store that data in the cloud. In this kind of a scenario, you need to be concerned about the privacy and security of that data, and that requires that you do some due diligence on the cloud provider to ensure that it is capable of providing adequate security. In addition, ideally you will have put in place appropriate contracts to ensure that the cloud provider actually provides the required privacy and security in accordance with the law applicable to your business. If, on the other hand, you provide cloud-based services, you need to remember that you're holding data from many different customers in many different locations that may be accessible worldwide. Yet each jurisdiction, and perhaps each customer, likely has its own privacy and security requirements.
How does somebody manage all those laws?
It's a complicated situation. Some have referred to this problem as information compliance overload. We are faced with an avalanche of privacy laws and security rules, and they come from many sources, including laws and regulations, common law obligations, contractual requirements, and standards of all type. They also come from many jurisdictions, including state and federal jurisdictions in the U.S. as well as a variety of international jurisdictions. And they cover many privacy and security subject areas, including breach notification, credit card processing, specific types of data like social security numbers or other forms of sensitive data, identity theft, spam, record retention, and record destruction. So keeping up with all of these legal requirements is clearly a challenge, but at the same time it's a necessary task. Thus, companies need to work closely with their legal counsel on these issues.
Given how easy it can be to move data, irrespective of whether you use cloud-based services, transferring data between countries without first understanding the applicable privacy laws could be a real risk.
Correct. For example, transferring data from the European Union to the United States should not be done unless you have a complete understanding of the applicable laws and you have taken appropriate steps to ensure that the transfer is legally authorized. There are several ways to do this, including entering into pre-approved so-called model contracts specified by the European Union, or obtaining specific consent from the EU residents whose data is involved, or becoming certified under the Safe Harbor program negotiated between the European Union and the U.S. Commerce Department. Keep in mind that the need for cross-border data transfers like this can also arise out of the normal or outside of the normal day-to-day business activities. For example, if your business is involved in litigation in the United States, you may, during the discovery phase of that litigation, need to collect information from a partner or subsidiary in the European Union. The problem you face here is that U.S. law may require your business to share that information with your adversary in the litigation, while at the same time the law of the applicable EU country may actually prohibit such sharing. This creates a very difficult situation and one where getting the advice of legal counsel is critical to resolving the impasse.
Let's assume a worst-case scenario, one that, unfortunately, seems to be increasingly more common. A data breach that wasn't immediately detected. Maybe a few days or weeks passed before the organization holding the data noticed the breach. What should the organization do?
Well, stopping and containing the breach is, of course, the top priority here. But when we look at it from a legal perspective, the first thing the company needs to do is to figure out exactly what happened. And this includes determining when the breach occurred, what data was compromised, how many records and what data elements are involved, what has likely happened, and if personal data was compromised, what jurisdictions the affected individuals reside in. This will allow the company to determine which laws and regulations are affected and what legal requirements it must satisfy. The company can then use this information to determine the scope of its notification requirements, including which individuals require notice, which regulators or enforcement agencies must be notified, such as state attorneys general or regulatory agencies, and what information must be disclosed as part of the notice. It also helps the company in responding to press inquiries.
That's a good overview. Recognizing, however, that every situation is different, are there traps that the organization could fall into if it isn't careful when handling a breach?
Absolutely. Failing to act quickly is one good example. Companies have gotten into trouble merely for taking too long to send out notices to the persons affected by the breach. Another problem is that they often fail to adequately prepare for the many inquiries they may receive from the press and from those affected by the breach. The public relations side of breach response is critical. Individuals may have significant concerns and need to get their questions answered. And how the breach is portrayed in the press can often have a significant impact on the company's reputation. But it's also important to recognize that breach notification is not the end of the legal or public relations process. The company often needs to be prepared to respond to inquiries from the Federal Trade Commission or state attorneys general. In addition to investigations to determine whether the company adequately complied with the requirements of the breach notification laws, such enforcement agencies may also open investigations to determine whether the occurrence of the breach indicates a failure to comply with other laws, such as laws requiring that the company implement an appropriate data security program to protect the data in the first place. And this is where having what's called a comprehensive information security program in place can be critical.
What's that?
A comprehensive information security program is a formal security program that contains specific elements and is tailored to a company's specific needs. It revolves around a process by which a company undertakes a risk-based analysis of its information systems to identify and assess the specific threats it faces. Based on the results of that process, the company designs and implements appropriate security controls to protect against those threats that were identified. Such a security program is really based on the view that data security requirements are relative to the specifics of each business and that there is no one-size-fits-all approach to data security compliance. So developing, implementing, and maintaining what's known as a comprehensive information security program requires a company to conduct periodic risk assessments to identify and assess the specific threats to its information assets, and then to evaluate the effectiveness of the security safeguards currently in place for minimizing such risks. Based on the results of that risk assessment and that evaluation, the company must then select and implement appropriate security controls to minimize the risks identified in its risk assessments. Now, some laws and regulations specifically require businesses to develop and implement a comprehensive information security program, and those laws typically mandate that the program must be in writing. And the Massachusetts security regulations are the prime example of a law of this type. But similar requirements are basically implied by most other security laws as well. It's also important to note that a comprehensive information security program is a combination technical, business, and legal document. Thus, developing it requires input and expertise from technical security experts, the appropriate business units of the organization, and an experienced data security attorney. All need to work together to achieve a security program that is technically appropriate, that meets the applicable business needs of the organization, and that is legally compliant.
Well, data security and privacy laws are evolving rapidly. What's new on the horizon?
Actually, several things are happening. One good example is the European Union is in the process of significantly revising its privacy and security law. And based on the draft released at the end of January 2012, those changes will have a significant impact on U.S. businesses that collect or obtain data from EU residents. In the United States, the Securities and Exchange Commission, or the SEC, adopted regulations last fall that impose a security risk disclosure requirement on public companies. These regulations go beyond breach notification obligations and require public companies to disclose even the risk of cyber incidents if such risks are among the most significant factors that make an investment in the company speculative or risky. And complying with this new requirement can also create other difficulties. For example, disclosing a security risk is tantamount to an admission that the risk is an issue that must be addressed by a company's comprehensive security program. And third, in addition, Congress has before it several cybersecurity bills that it's currently considering, and these may also result in a variety of new data security obligations for businesses if these are enacted by the end of the year.
As I see it, determining how to comply with data privacy and security laws, but only after first determining whether you're subject to those laws, is incredibly complicated. Just determining which laws apply to you because you engage in business with people or companies outside of your state or country can be mind-boggling.
Absolutely. This is an extremely complex and fast-moving area of the law. And since this is a major focus of our practice, we devote a significant portion of our time simply to keeping up to date with this constantly changing legal landscape. Also, we try to educate our clients on the requirements of a comprehensive security program, as well as assisting them in regularly reviewing it and adjusting it in response to the changes in the law.
And then there's the ongoing training.
Correct. Many statutes and regulations specifically require periodic employee training and education regarding security and privacy. And to assist in that process, we provide regular training to businesses to help keep their people and their organizations well aware of changes in data privacy and security laws. This ensures that they are ready to comply with those laws as necessary.
Thanks, Tom, for this brief overview of a very complex area of law. Any person or business dealing with these issues should do so only after getting proper legal advice from an attorney. We hope that you found this podcast helpful in understanding data privacy and security. Stay tuned for our next installment in Computer Magazine, which will cover responding to a patent infringement lawsuit. Until next time, this is Brian Gaff
and Tom Smedinghoff.
Feel free to contact us via email at bgaff@edwardswildman.com
or at tsmedinghoff@edwardswildman.com.
Thank you.